LoudLilDucky coming through, speaking truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose their hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. A sparking revolution, it's a truth-telling tale.
Alrighty, guys. How is everybody tonight? We are just going to bring, do I have everything up yet? No. Should I? Yes. All right. I want to make sure that there's no sound going on for the background music, because I always forget to turn off the background music in a live. So, okay. Now let's bring this up. So, Gingras has filed a motion, which we knew that this would be coming, because, well, him and Owens have been doing, their so-called PR. Not Gingras as much because he's been on his vacation, but definitely Owens and all her Medium articles. And I decided that I was not going to cover the Medium articles because it is just her regurgitating what is already known out there. And I don't need to go over that again and again and again. And her spinning her stories, it's just not something that we need to do or I care to do. I've watched it and seen it on other people's channels and things like that. But I decided I wasn't going to do it. She can sit there and write all that. She'll go back and edit it. But what matters is what was shown in court and what was at the hearing on June 10th. So that is what we are focusing on. We are focusing on the case part of it. So let's bring this up because this is the case that's never going to end. All right. So we have Owens claims bias and wants a new judge. Here's Gingras on vacation. It's very pixelated, but it's he's mad and upset and demands things. All right, so first, let's go here. All right, let me see. Let me see if I can do, uh-oh, what did I just do? Camera slot. Oh, okay, so let's just and then Media slot. There we go. Let's change it to that. Hold on here. I am kind of doing a new layout. Let's see. Sorry. You're going to watch me do this on the fly. I've not done this before, but I'm going to make this bigger. Okay. Okay, we're going to change it to this one. Okay. All right. So now that we kind of have our new layout. So it starts with Gingras is filing this in the matters of Owens v. Eckerd. And this is in the Maricopa County Superior Court, State of Arizona. And this is a notice of change of judge for cause, memorandum and affidavit in support. And it is to the notice judge, which is the Honorable Judge Matta, and to the presiding judge, Honorable Rhonda Fisk. Pursuant to Rule 6.1, Arizona Rules Family Law, petitioner Laura Owens, Laura or petitioner, submits the following notice of change of judge for cause and memorandum and affidavit in support thereof. As explained below, there is clear and convincing evidence demonstrating the judge currently assigned to this matter, Honorable Judge Julie Matta, is biased, prejudiced, and has engaged in conduct which violates both Laura's right to due process of law under the United States and Arizona constitutions, which separately violate the Rules 2.9a and 2.9c of the Arizona Rules of Judicial Conduct by inter alia. 1. Performing an independent investigation into the facts of this case. 2. Considering and relying upon information posted on the internet about this case. And 3. Engaging in ex parte communications regarding this case with her father, Harry L. Howe. Well, we knew that she was going to bring her father into this, Judge Matta's dad into this. That was already stated. And so we knew this was coming. Let me, hold on just one second. I'm going to turn on the light. That might be better. I am okay. That might be a little bit better. There we go. Okay. So this conduct, while sufficient to warrant additional other relief, including but not limited to a new trial, establishes grounds to disqualify Judge Matta on the basis of bias and prejudice within the meaning of ARS 124095. For these reasons, Laura respectfully requests the family court presiding judge, Honorable Rhonda Fisk, review this matter and to find that grounds exist to disqualify Judge Matta and promptly reassign this matter to a new judge. Great. In the event Judge Matta disputes the allegations set forth below, Laura requests that family court presiding judge set this matter for an evidentiary hearing pursuant to Family Law Rule 6.1d2. And that upon doing so, the court approved the issuance of subpoenas and testification to Judge Matta and her father, Mr. Howe. Like, really? The father has to come in here? Like, this is ridiculous. Her dad was not in the actual courtroom. He was in the overflow room. Judge Matta's dad also a person himself, just an individual himself. Is everything that you do in alliance with your parents? Probably not. You can live in the same household as your parents, and the things that you are interested in and the things that your parents are interested in or your siblings are interested in can all be different. Judge Matta, I don't know how much and how little people can talk about their cases. I don't know, because I'm not a lawyer, I'm not a judge. So I don't know if they can be like, oh my gosh, this Owens case again. Or does Judge Matta's dad just pay attention to things in that courtroom because his daughter is presiding over it, and so he's interested in seeing what she's up to because maybe she can't talk to it? He can do that all on his own. Like, he is his own person. Just because he took interest in this case, because it's a huge case in that area, does not mean that they are in cahoots and conspiring against each other. That's just not, just because Owens family does that doesn't mean that everybody in the United States families conspire and do all that. But okay. In the event, okay, we already read that. Case and summary, background. The facts of the matter are set forth in detail in the affidavit counsel submitted herewith. In short, the case began as a simple paternity establishment action with one uncommon wrinkle. Respondent Clayton Eckerd, Clayton or respondent, is a minor celebrity as a result of his appearance on reality TV dating program called The Bachelor. Clayton did not merely appear as a contestant on The Bachelor, he was the star of his season. Well, he did appear as a contestant first on The Bachelorette, and then he became the star of his season, appearing on the show from January to March 2022. And you know what you're probably going to find, Gingras, is that most of the people that are in this Justice for Clayton thing probably didn't watch his season. I didn't watch his season. I've seen a lot of other seasons. I go back and forth between watching it and not watching it. I just didn't watch his season. But okay, let's see. Laura claims she had a one-night sexual encounter with Clayton in Scottsdale on May 20th, 2023, and she learned she was pregnant 11 days later. Laura claims she tested positive for pregnancy on 5 separate occasions on an HCG pee stick. Yep. Okay. Before this case was filed, May 31st, June 1st, June 19th, July 25th, and August 1st. The first test was taken on May 31st, was an at-home type pregnancy test, which was positive. The next day, on June 1st, Laura went to Banner Urgent Care for a professional pregnancy test. The test at Banner was also positive. And I get, like, okay. Most of you know how I feel about this, the Banner Urgent Care thing. But one of my big problems with the Banner Urgent Care pregnancy test the day after you took an at-home pregnancy test is you're just going to take the same thing, but I get you're getting a doctor to say, yes, I saw the pee stick test and she did it here. Also, those doctors don't follow you into the bathroom because she wasn't taking a drug test or anything like that. So she just went and had a doctor verify the pregnancy. Now, with her only being 11 days or 12 days, maybe at that point, I don't even know if could they have done an HCG test on her as well as the P stick test? Yes. I don't know if at 11 days they would even do a internal sonogram instead of the over the belly, because she was only 11 to 12 days along when she went to Banner Health. So essentially all she wanted was a doctor to say, see, I have a positive pregnancy test. But that pregnancy test does not tell anybody who the father is. She says she's not sleeping with anybody, but we don't know that for a fact. I don't believe she was. I mean, just because she attaches to every person she sleeps with. So I don't know. I don't know why or how she thought she was going to get away with this one. This one was just not the one to go for. And he says, of course, the test at Banner was positive. After Laura informed Clayton of these positive tests on June 19th, 2023, Clayton invited Laura to his home to discuss the situation. Upon arrival, Clayton surprised Laura with a home pregnancy test he had purchased, and he demanded she take the test immediately in front of him. Laura claims she took the test as Clayton watched, while Clayton claims she went to the bathroom and took the test behind a closed door or a partially closed door. In any event, this third test was also positive. Once again, we believe she can be positive. We just don't know that that means she's pregnant, because we have nothing else to go by. After the parties were unable to reach an agreement on how to deal with the situation, and after 2 more positive tests, Laura filed this action on August 1st, 2023. Upon filing and through the present, this matter was assigned to Honorable Julie Matta. On August 21st, 2023, Clayton filed a pro se response denying paternity. In his response, Clayton claimed only oral occurred between the parties, not intercourse. And he further alleged this entire petition is made up by Laura. Yeah, I would say that too if I only had oral. What else is a guy supposed to do? How is he supposed to believe this? Like, this is not what we're taught in sex ed. Like, I'd be going to my 8th grade teacher. I'd be like, did you lie to me? Miss Smith, you said that you could only get pregnant this way. And here I am. Apparently, I've impregnated a girl by not having intercourse. Miss Smith, the 8th grade teacher, she's going to have some explaining to do. Because we all been lied to in sex ed if this happened. Laura claims that while the matter was pending, she had a blood test done on October 16th, 2023, which confirmed yet again she was pregnant. But the test results suggested the pregnancy was not viable, i.e., it was likely to end in a miscarriage. Is there stuff from that doctor telling her that? No, because she went to, there wouldn't be a doctor because she just went to like any labs now or something like that to get this test done. So there is no doctor to tell her that. She would have just had these and then whatever. But what he's missing here is prior to her filing on August 1st, in July, she supposedly had that tissue and bleeding and stuff. The miscarriage, the vanishing twin or something that wasn't absorbed because it came out of her. Because that, if it's vanishing and it gets reabsorbed, then why does she exposing fetal tissue, which I don't believe is fetal tissue. I believe it was a period. And we had to see that disgusting stuff. But yeah, you're missing that in here. About a month later, on November 14th, 2023, Laura was seen by an OBGYN facility called MomDoc, where it was confirmed she was no longer pregnant. And after she had been called out on her lies by Deandra, the attorney for Clayton. I just add that little footnote in there. After learning she was no longer pregnant, Laura filed nothing further in the case, and she took no action to prosecute the matter any further. Because Laura is not an attorney, she was not familiar with the process for seeking a voluntary dismissal. I do not buy this lie. She has been in court case after court case after court case. She could figure it out. You could seriously just Google how to dismiss a case in Maricopa County, Arizona. And guess what? You would find the stuff and probably a form that you could fill out and submit to the court to dismiss. Like, it's not rocket science to just do something that simple. On December 4th, 2023, court administration issued a notice placing this matter on the inactive calendar and scheduling the matter for dismissal on February 2nd, 2024. Shortly before the case was due to be dismissed for inactivity, Clayton retained counsel. Yeah, because he said, no, I'm not going to let her get away with this. She's not going to just get to dismiss this and claim miscarriage after she has slandered and libeled my name all over the place. And people think that I'm this deadbeat guy. He isn't going to let that happen. So yeah, he retained counsel with the help of some people. Greg Woodnick, who appeared in this matter for the first time on December 12th, 2023. Mr. Woodnick immediately filed several pleadings, including a motion to amend Clayton's answer to petition filed on December 12th, 2023, and a motion for Rule 26 sanctions filed on January 2nd, 2023. Notably, Mr. Woodnick filed these pleadings without making any attempt to meet and confer with Laura as required by Family Law Rule 9C. And he moved for Rule 26 sanctions without ever providing written notice to Laura of her right to amend and withdraw her petition required by Family Law Rule 26C2B. Really? He's bringing up Sanction 26 again. That has been withdrawn. Nobody cares about Woodnick's Rule 26 sanctions for Owens because it was withdrawn. Stop talking about it. Shortly thereafter, Laura retained counsel Alexis Linval, who appeared on December 22nd, 2023, and filed a motion to dismiss with prejudice on December 28th, 2023. Days later, Ms. Linval withdrew from the matter with Laura's consent on January 2nd, 2024. And then Laura filed a bar complaint on Ms. Linval. We're just going to add the subtext in here that he doesn't like to mention. Let's make her all seem like she's just angelic and she's just so mistreated. Confusingly, on January 25th, 2024, Judge Matta issued an order granting Laura's motion to dismiss. In that court ruling, indicated petitioner advises she is no longer pregnant and has filed a motion to dismiss. While the court will grant the motion, the issue of sanctions and attorney's fees remain. Judge Matta set an evidentiary hearing on those issues for June 10th, 2024. Okay. Well, we've got to find out about sanctions. And part of that in the sanctions thing was to find out if she was lying or not. Did she disobey court orders? Yes, she did. And did Clayton deserve attorney's fees for all the crap that Owens put him through? Yes, he does. So he's just going to say, well, she didn't have the right to say this, this, and this. Well, she did. And if it's just to get to sanctions and to attorney's fees, then her stating that she doesn't find it credible that he was the father, she doesn't find Owens credible, she didn't find any of this. These are all her reasons, her disobeying court orders and not providing all the discovery from Los Angeles is her reasonings for sanctions and granting attorney's fees. So whether she can find those or not, they back up her reasons for sanctions and attorney's fees either way. She put them in there. She let everybody know what she thought. The undersigned was first retained to represent Laura on March 25th, 2024. After appearing in this case, undersigned counsel quickly discovered that Mr. Woodnick filed a Rule 26 motion for sanctions, among other pleadings, without first consulting with Laura or her counsel. And the sanctions motion was filed without giving mandatory 10-day written warning required by providing written notice to Laura of her right to withdraw her petition as required by Family Law Rule 26C2B. After counsel discussed these problems and despite initially refusing to do so, on April 3rd, 2024, Mr. Woodnick filed a motion to withdraw his Rule 26 motions for sanctions. Unfortunately, that request was not timely ruled on by the court, resulting in the undersigned filing a motion for judgment on the pleadings as to the issue of sanctions on May 10th, 2024. Yes, there was some clerical error in determining, or in that it didn't get filed when it should have. On May 29th, that says 2029. Oh, you want to talk about errors in your pleadings? You have 2029 here, Gingras. But everybody makes mistakes. It should be 2024. A minute entry order was issued explaining the court had intended to grant Clayton's request to withdraw his motion for sanctions, but due to a clerical error, the acceptance was not remitted to the parties. Despite the motion for sanctions being withdrawn and despite no other sanctions or fees motions pending, the case proceeded to trial on June 10th, 2024. Yes, because there are other sanctions other than your Rule 26 one that Woodnick wanted. There are other things. On June 17th, 2024, filed June 18th, 2024, Judge Matta issued an order finding in favor of Clayton as to substantially all issues in the case and awarding attorney's fees in an amount to be determined by later application. The post-trial order also purported to find Laura lied about being pregnant in this case, as well as two other matters that she may have committed perjury in this case or elsewhere. The order is not entirely clear. Based on those feelings, Judge Matta referred this matter to Maricopa County Attorney's Office. Yeah, as she should. Since receiving the post-trial decision, Laura has discovered evidence of extremely serious misconduct by Judge Matta, which is more than sufficient to remove her from this case for cause. Laura will also seek, by separate motion, a new trial and a complete reversal of all prior rulings issued in this case by Judge Matta due to her misconduct in addition to other relief. And as BDC said at the beginning of this live stream, 10 judges could see this, and they're still going to find the same thing as Judge Matta. But okay. So, the legal standard. Family Law Rule 6.1.a provides A, grounds from the Darrell Brooks. A party seeking a change of judge for cause must establish grounds by affidavit as required by ARS 12409. Among other reasons, ARS 12409 permits disqualification of a judge by showing the party filing the affidavit has cause to believe and does believe that on account of the bias, prejudice, or interest of the judge, he cannot obtain a fair and impartial trial. I think Owens had every chance. She had over a year. No, she didn't. She didn't have over a year. Almost a year. To have a fair hearing, to submit all discovery. And what did she decide to do? She decided to still not show any evidence. She could have gotten something that in her mind and her attorney's mind would have shown that she was pregnant for sure. But instead she kept that to herself, like to make her look more like a liar. Like if that was going to prove the whole case and it would have proved that she was telling the truth, why are you keeping that hidden? I have my suspicions as to why, because it doesn't exist and it's not real and it wouldn't show anything. It is important to note ARS 12409 does not contain any express time limits for seeking a change of judge, but Arizona courts have read that statute as containing an implicit limit. A party cannot ask to disqualify a judge under ARS 12409 after a trial has begun. See Del Castillo v. Wells. That is a 1974. Explaining under ARS 12409, if a judge is allowed to receive evidence which is of necessity is to be used and weighed in deciding the ultimate issues, it is too late to disqualify him on the grounds of bias and prejudice. Well, see, she already made her ruling. So, and the trial and the evidentiary hearing already happened. So I'll be interested to see where he's going with this. At the same time, the Del Castillo court also noted requests to disqualify a judge made under other authority, not ARS 12409, such as Civil Procedure Rule 42F, are not subject to the same implicit restrictions as restricted under 12409. Instead, Del Castillo explains if a request is made under authority, the outcome is controlled by the text and substance of a specific ruling invoked, clearly enacting Civil Procedure Rule 42F, providing for specific procedure for change of judge. The Supreme Court modified or suspended the then existing procedure for change of judge as a matter of right outlined in 12409 Del Castillo. Thus, for example, in a civil matter, a party may waive his or her rights to change judge as a matter of right if the judge rules on any contested issue. Okay, well, she's ruled on these contested issues. So, doesn't that mean you've waived your right? Okay. I don't know how this is helping you right now, Gingras. Here, Family Law Rule 6.1 does not contain the same waiver language. On the contrary, Rule 6.1 only requires that a party seek a change of judge for cause within 20 days after discovering the basis for the request. And the rule expressly provides case events or actions taken before that discovery do not waive a party's right to change of judge for cause. Emphasis added. Case events or actions taken before that discovery. Okay, but that's all right. The broader rule, which permits a change of judge after trial, makes sense that given family law cases, unlike civil matters, often continuing in nature, because a family court judge may hold multiple trials or evidentiary hearings in the case over a span of many years, it would make no sense to interpret Rule 6.1 as depriving a party of their rights to disqualify a judge for cause simply because the judge held one or more earlier hearings before the grounds for disqualification were discovered. Rather, the text of the rule merely requires a party to raise the issue promptly, even if that occurs after a trial or hearing is completed. Okay. As explained in the concurrent filing affidavit of counsel, the grounds upon which a change of judge are requested in this case are primarily based on misconduct committed by Judge Matta, which shows her post-trial rulings, filed June 18th, 2024, contained findings that were not based on the evidence admitted at trial. Rather, Judge Matta made findings based on improper ex parte investigation she conducted, which included reviewing information posted on the internet about this case. I would like to know where his proof is of this. Also, in a lot of filings, sadly in this case, there were YouTube links to things and screenshots of social media things that they were like, hey, take a look at. I think most of the YouTube link things came from Gingras, whereas Woodnick just had like screenshots of things and just put them in his things. He didn't have like links to YouTube videos, but I could be misremembering. Until Judge Matta's post-trial ruling was issued on June 18, 2024, less than 20 days ago, Laura did not know and could not possibly have known of the judge's misconduct in this regard. Okay, I'm wondering how you know of this misconduct. Where is your proof? Did you see her watch a YouTube video? Although this single issue is sufficient to grant the relief requested, there is also evidence showing other misconduct committed by Judge Matta, including the fact she engaged in improper ex parte discussion of the facts of this case with her father, Harry L. Howe. I don't think there's proof of that either. Because, like I said, Judge Matta's dad is an independent person. He couldn't have possibly just looked at things his own, heard about this crazy story that was happening in his daughter's courtroom and looked into it all by himself. All of it had to come from his daughter. No. Like, you don't know what was discussed. This reminds me of parts of the Maya Kowalski case where they're like, oh, the juror is married. And his wife was like watching things online about the case. And they had to have talked about it. Where is your proof? Just because her dad ended up finding this interesting because it was happening in his daughter's courtroom doesn't mean that they were having conversations. Do you have subpoenaed text messages, recorded phone calls? Like, what do you have to prove this? You have nothing. Except for somebody saying that Judge Matta's dad was here to watch it, and he was in the overflow room, not even in the courtroom. Like, you have so little to go on, you're going to have to prove these big, huge claims that you're making. In violation of Rule 2.9A of the Arizona Code of Judicial Conduct. Although Laura, an undersigned counsel, heard rumors about Mr. Howe appearing at the trial on June 10th, the specific details of exactly what occurred and proof to establish these facts was not fully known until undersigned counsel returned from his pre-planned vacation on June 28th, 2024. Okay. So you now have facts to establish this other than just rumors? Because I would like to know what these are. Do they get into this? Does he show he has facts? Anybody that's already gone through this? For those reasons, this request is timely pursuant to Family Law Rule 6.1c because it has been brought within 20 days of discovering the grounds upon which the request is based. Okay. June 10th. I don't know what. So that would have been on June 10th. June 10th, you would have known about these rumors, right? So isn't June 8th? Isn't that past 20 days? Maybe not. Maybe this wasn't filed on June 8th. Maybe it was June 7th. But it's still closer to 30 days than 20 days. So I don't. But he's saying he didn't know about it until June 28th. That's a lie. Like, I believe that that's a lie outright. Because I think he knew about it as of June 10th. Because he talked about it in his blog post. So to me, it would need to be 20 days from June 10th. Or when he mentioned it in his blog post of the rumors. But if you've got proof, okay. But I want to look at this Rule 2.9 C. Arizona Code Judicial Conduct. Okay. A judge shall not investigate facts in matter independently and shall consider only the evidence presented. Dang it. A judge shall not. Dang it. What is it? Okay. 2.9. Okay. Judge shall not investigate facts in the matter independently and shall consider only the evidence present and any facts that properly be judicially noticed. Okay. Inadvertently receives unauthorized expertise. Judge. Okay. I may just go over that in like a short or something like that, just to put it out there. Okay. Discussion. A. Clear and convincing evidence shows Judge Matta conducted an improper ex parte investigation into the facts. Okay. I want to hear this. The details of the grounds for disqualification are set forth in the affidavit of counsel submitted herewith. To summarize those grounds, this request is primarily based on fact there is clear irrefutable evidence that Judge Matta conducted an ex parte investigation into the facts of this case, and even worse, at least one of the post-trial factual findings on critical important issues was based solely on information posted on the internet and not based on the evidence admitted at trial. Okay. Like, is he going to get to any of the proof in this? Because I'm just waiting. This is just all words. Because episodes of such brazen and blatant judicial misconducts are thankfully rare, comparable examples in Arizona are difficult to find. However, something very similar occurred in the reprimand of Judge B. Carlton Terry Jr., North Carolina Judicial Standards Commissioner Inquiry in April 1st of 2009, a copy of which is submitted here within. And then they attached that. The case, like this matter, involved a family court proceeding. In Terry, the assigned judge posted comments about the case on Facebook, and he also used the internet site Google to find information about a party's photography business. The judge also viewed the website of a party and copied a poem from that party's website, which he recited at trial. Upon discovering these facts, one of the parties moved to disqualify the judge and asked to vacate the judge's post-trial orders and to have the case reassigned. Those requests were granted in their entirety, and the North Carolina Judicial Standards Commissioner later publicly reprimanded the judge for this conduct, finding he committed multiple violations of the canons of judicial conduct, including by conducting an independent ex parte online research about the party presently before the court, and by having an ex parte discussion about the case. The commissioner found the judge's actions were prejudicial to the administration of justice that brings the judicial office into disrepute. Exactly the same rules and standards apply here. It is axiomatic that in civil cases in the state of Arizona, juries are never permitted to conduct trial by Google. Okay. Well, we don't have a jury, so I guess the judge can't. But once again, we don't have a jury. Research related to this case, included an internet search, is strictly forbidden. Do not do any research or conduct any type of investigation about the case, the facts, the parties, the witnesses, the attorneys, or any person or entity related to the case. Do not look for information on the internet or from any other source about the case or about the facts or issues related to the case. In other words, do not try to find out information from any source outside this courtroom. The reason for this is that you must be based in any decision only on the evidence that is produced here in the courtroom. You must base any decision only in the evidence that is produced here in the courtroom because the fairness of the trial depends on both parties knowing exactly what evidence you are considering so that they can respond to it or address it in their arguments. Revised Jury Instructions, Civil 7th Preliminary 9. Okay. We're not dealing with a jury, we're dealing with a judge, but I get your point. Notwithstanding all of their other powers and responsibilities, judges acting as fact finders in a bench trial are subject to exactly the same rules as jurors. A judge may never investigate facts in the matter independently and shall consider only the evidence presented and any facts that may poorly or properly be judicially noticed. Arizona Supreme Court Rule 81, Code of Judicial Conduct, Rule 2.9c, and Comment 6, explaining the prohibition against a judge independently investigating the facts in a matter extends to information available in all mediums, including electronic. Okay. And he's going to go into a hypothetical. So why do we need a hypothetical if she did this and you have proof that she did this? You're just putting a bunch of citing things. All right. The prohibition against okay. Exact same rules shall consider the evidence. Okay. As explained in the affidavit or of counsel submitted here within, there is no question Judge Matta violated the most basic core requirement of fairness. She did so by making a critical factual finding. The Planned Parenthood is closed on Sunday, and by falsely attributing that finding to a trial witness, Clayton's medical expert, Dr. Deans, who said no such things. Rather than basing this finding of the evidence admitted at trial, the only possible source of this information was an independent investigation into the facts of this case by the judge, which included looking at social media and other websites' comments. It is irrelevant exactly which sites Judge Matta viewed or when she viewed them, because any such ex parte investigation was a per se a violation of Laura's right to fundamental fairness. Well, what if she knows Planned Parenthood is not open on the weekends? Also, I thought somebody had said that Deans had put it in one of her opinions or something. Or she stated maybe that they weren't open on the weekends or something like that. I don't know if this is a thing, because even if you take out that particular thing, that Planned Parenthood is closed on Sunday, the fact that she still did not provide the discovery for the Los Angeles Planned Parenthood that she claimed during the hearing, I think she would have still found this out, like still made this finding But okay, this is about the closed on Sunday comment. And the judge should just be kicked off the case for closed on Sunday. All right. Furthermore, although Judicial Conduct Rule 2.9c does allow a judge to base findings on facts which may properly be judicially noticed, the business hours of Planned Parenthood locations in California in 2023 is not a fact subject to judicial notice, nor did Judge Matta claim she took judicial notice of that fact. This exact issue was discussed in ABA Formal Opinion 478, which offered the following hypothetical. Hypothetical 1. In a proceeding before the judge in a case involving overtime pay, defendant's counsel explains that if plaintiff could not have worked more than 40 hours per week because defendant's restaurant is in an industrial area and only open for breaks and lunch, breakfast and lunch during the work week and not on weekends, the judge is familiar with the area and skeptical of counsel's claims. The judge checks the website like Yelp and Google Maps, which lists the restaurant is open from 7 a.m. to 10 p.m. 7 days each week. Does this search violate Rule 29 or 2.9c of the Model Code of Judicial Conduct? Analysis 1. This search violates Rule 2.9c of the Model Code of Judicial Conduct because the restaurant's hours of operation are key to whether the plaintiff could prevail on a claim of unpaid overtime. The judge should ask the parties and their counsels to provide admissible evidence as to the restaurant's hours of operation. Okay. And I'm guessing nobody submitted the hours of Planned Parenthood. Maybe Dr. Dean didn't provide the hours of Planned Parenthood. But okay, I feel like it's stated somewhere. If it's not, these are the little nitpicky things that lawyers are going to find. ABA Formal Opinion 47.8, Independent Factual Research by Judge via the Internet, December 8, 2017, emphasis added, footnote 2. And he's got a link to this thing. Again, because such blatant misconduct is rare, there's no directly controlling comparable Arizona precedent on this issue. Of course, the Code of Judicial Conduct, as adopted by Arizona Supreme Court, is controlling here. However, courts in other states have consistently agreed. This type of judicial misconduct is per se unlawful, and it entitles the movement to automatic relief regardless of whether the error was harmless. See Davis v. United States. That was in a 1989, reversing convictions and ordering new trial, where judge asked a law clerk to perform independent investigation into the facts of the case and explaining under our system of laws, a judge is not an investigator. The investigative functions belongs to the parties and their agents. Okay. So if she gets a new trial and a new judge, guess what? She's still going to be a liar. I'm just going to say that. Laudable goals and lofty purposes cannot be attained when the cost is the loss or even the appearance of loss of judicial impartiality. Emphasis added, citing Kennedy v. Great Atlantic and Pacific Tea Co. That is from 1977, reversing conviction and ordering a new trial, where the trial judge law clerk personally visited the scene of the slip and fall accident, and the clerk later testified about the outcome of his investigation. It was unacceptable. Okay, well, that is unacceptable. Like, the law clerk does not need to be doing all that and reporting back. That's not what we have going here. Brought to the intervention court. It was the law clerk's duty, as much as the trial judge, to avoid any contacts outside the record that might affect the outcome of litigation, and further explaining the law clerk's private view of an accident in litigation was prohibited ex parte, is what I'm guessing. Okay, that has nothing to do with our case. Communication was violated. State v. Dorsey 701 is a Minnesota case from 2005, reversing conviction and order a new trial after a judge independently investigated facts of a case, noting such conduct constitutes a per se violation of due process, which requires automatic reversal without applying harmless error analysis. When a defendant has been deprived of an impartial judge, automatic reversal is required. This deprivation constituted a structural error which precludes harmless error analysis, emphasis added, Arizona v. something, which is 1991. Based on this authority, Judge Matta must be disqualified on the basis of bias and prejudice as reflected by her gross misconduct. Okay. Like, he's being hyperbolic here. But, okay, if she did, I don't know if she did. It could have been stated somewhere. Do I think Gingras combed through everything? Yes. Did he probably listen to the trial again to see if or looked at the transcripts, which is probably why he has the transcripts attached? Like, okay, let's say Judge Matta did look at the hours and didn't get it from any type of evidence or affidavits or anything that was submitted in the case or said in this case, and she actually Googled it. I mean, I don't know if that's like gross misconduct. Like, that conduct in comparison with Owens' conduct is gross. Should Judge Matta be doing that if she's not allowed to? No. Do we know if for sure she did this? No. Misconduct. There is no question one of the most critical factual findings in this case was the issue of whether Planned Parenthood is closed on Sunday. No, I don't think that was the biggest issue, is whether they were closed on Sunday. It's the fact that there's 3 different dates that she supposedly went to Planned Parenthood. And there's like 3 different locations of Planned Parenthood that she supposedly went to, in which we have no evidence of her being at any of them. 1, because she didn't go there. Or 2, because she didn't go there. And 3, she probably didn't go there for the 3rd one. And she didn't even let anybody know about it until the hearing. So she can find that not credible based on that. The specific reasons why the fact was critical are explained in greater detail in the affidavit of counsel submitted herewith. In the post-trial ruling, Judge Matta made a specific finding that Planned Parenthood is closed on Sunday, and she attributed that statement to the testimony of Clayton's medical expert, Dr. Samantha Deans. But the trial transcript leaves zero question. Dr. Deans never testified to this fact, nor did any other witness. Moreover, on the day of trial, this fact was repeatedly and broadly published on social media sites and by anonymous third-party comments appearing on the personal website of undersigned counsel. Was it in Dr. Dean's opinion that was submitted and taken under review? And I think there's some stuff that we still haven't been able to see in this case. I don't know if we got all of the medical expert report or just parts of it that Gingras put on. So it'll be interesting to see what is said about this particular issue. The facts demonstrate that Judge Matta did exactly what the rules expressly prohibited. She conducted her own independent investigation into the facts and then used the results of the investigation to reach an adverse decision. I don't think closed on Sunday was the whole reason for her adverse decision to your client. I'm pretty sure your client in general was the cause of this adverse decision to her. This is a profound violation of Laura's rights and the rights of the people of Maricopa County who trust their disputes will be settled by impartial jurists according to the law. To be impartial, the fact finder must base its conclusions on facts and evidence and must not reach conclusions based on evidence sought or obtained beyond that adduced in court. When the fact finder violates this principle, the result is structural error requiring automatic reversal. State v. Foote, and that is 2020 Minnesota, I think. That's what Min means, I'm guessing. Quoting Dorsey, Tribute, Delaware 2008. We hold that the family court committed a reversible error when it rejected unrefuted testimony by the husband's expert and substituted for the testimony the results of its own internet search, emphasis added. Okay. B. Other evidence supports a finding of judicial bias. Okay. So it's not just closed on Sunday. The law is clear. A single instance of misconduct by trial judge is sufficient to establish biases and require disqualification of the judge, as explained above. The evidence proves that Judge Matta undertook an independent investigation into the facts, and by doing so, she manifested bias sufficient to require her disqualification. But the evidence of bias and misconduct is not just limited to Planned Parenthood is closed on Sunday. Rather, as explained in the affidavit of counsel submitted herewith, another separate issue also establishes Judge Matta's bias. There is evidence showing the judge shared information about this case with her father, Harry Howe, and that he not only appeared at the trial as a spectator, he later socialized with Clayton's cult-like supporters, telling them comically, "I'm here for the shit show." And this is where I believe you're going to look like an idiot, because I don't know if that's a quote or just a summary of kind of what he said. It also still does not prove that Judge Matta was talking to her dad about this case. He could have heard about it and seen it all on his own. But, nobody is there is their independent person. Everybody is doing something. Just because your client is always up to something, everybody else isn't always up to something. It is difficult to image a more disrespectful, disreputable, and disgraceful act for any judge to commit than inviting her father to attend a high-profile trial in support of a party. Who said she invited him? He could have invited himself. He could have just been like, you know what? I know this is going down. I'm going to go watch it because I want to see what she has to say or see what really happens in this thing. Like, is this real? I got to see this live because I've seen it all over the interwebs. I'm going to watch this because is it going to be that bad for real? Or is she going to come clean? Like, he could have just had genuine curiosity himself, and it's his daughter's court. It is not the first time that a family member has gone and sat and watched their judge, whether it's their son, the judge, or their sister or brother, the judge, their mother, the judge, the dad, the judge, their daughter, the judge. Family can go watch. It's open to the public. He is a part of the public. There's nothing against that. While also privately engaging prohibited ex parte discussions about the case with her father, these actions made a mockery of the proceedings. As shown in the video clips submitted herewith, Clayton's supporters gleefully celebrated Judge Matta's father's participation in the case, even going so far as to laughingly asking people not to spread information about his participation because, after all, we don't need a mistrial here. For once, the followers are exactly right. The conduct of Judge Matta and her father obviously warrant a mistrial, or more accurately, a retrial before a different unbiased judge. In my opinion, do I think that this needed to be stated? No. I get people being excited, but I don't know. There's just things you should and should not do. That if you're on one side or the other, it could make things worse for the other side. And in the age of the internet and everything, we're going to learn more and more about it. That you can go and watch certain things. There are some things that you can't see or that you can't spectate on, and there are things that maybe you can't or shouldn't talk about. And he was probably just sitting in the overflow room, not just congregating and partying it up with the Justice for Clayton people. He was probably just sitting in the room watching his daughter, and he might have said, yeah, that's my daughter, and I'm here to watch this crazy thing unravel or whatever. I don't know that he said, I'm here for the shit show. That we don't know for sure whether that's exactly what he said or not. We know that that was said by somebody, but he wasn't I don't think he was purposely trying to surround himself with the Justice for Clayton and be biased and stuff. I think he was just sitting where he was sitting, and it's not anybody's fault that nobody is there for her. So yeah, those might have been the people that are around him. We're not a cult. We're looking for justice and the truth. But I don't think that he fully did anything wrong. This shameful conduct not only violated Laura's rights, it raises serious questions regarding Judge Matta's fitness as a judge of the Superior Court. Any reasonable objective observer in Laura's position would be justified in wondering, was my case fairly decided on based on the evidence, or was Judge Matta simply trying to impress her father? Look at me, Daddy. I'm a real judge now. Just watch me destroy a young woman's life because the other party was on The Bachelor. Hee hee. No, that's what Owens would have done. That's not what Judge Matta was doing. Judge Matta has had plenty of cases, and her father has probably gone and watched some of those too. So, you're just going on rumor. You have nothing to back any of this stuff up. Assuming the published allegations of Judge Matta are true, as documented on the video by Clayton's own followers, this proves Judge Matta separately violated Rule 2.9a of the Code of Judicial Conduct, and Judge Matta's blatant, pervasive disregard for her ethical duties and disrespect for Laura's fundamental rights explain the judgment's numerous and otherwise heretofore inexplicable adverse rulings during this action. No, I don't think any of that. I think you can find somebody you can go find a judge in any state, and they're going to look at this and call bullshit on Owens. Whether they're biased or unbiased, you're not going to find somebody that's like, oh, yes, poor little her. So the fact that without all of this, without her being a cult member too, she never would have ruled this way. That's just foolish thinking. As a general rule, Prejudice or bias is a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants in regard guardianship of stare 1975. At the same time, to prove prejudiced or biased, an appellant must point to relevant facts other than adverse judicial rulings in marriage of Kentop. Bias and prejudice necessary to disqualify a judge must arise from an actual judicial source. Okay, so like you still have not shown where Judge Matta did anything wrong. Her dad went to watch the thing. You have no proof that she invited him. You have no proof that she was talking to him about this case at all. You do not have online a quote or anything, an interview or anything from Judge Matta or her father directly saying anything. You have hearsay upon hearsay upon hearsay is what you have as a rumor. Would it not set right with me if that was my case? I probably would be bothered by it too. But depending on what was done, like the fact that they just can't see anything else and that it has to be that she's biased and she's a part of a cult and so is her dad, and that there's no other way for her to have found that she was a liar because nobody else in the world would possibly think this way is ridiculous, and it's living in delusion. The unique facts and circumstances described above make this case one of exceedingly rare exceptions in which the trial judge manifests clear prejudice and or bias early in the proceedings, in the form of multiple unexplained adverse rulings described in the affidavit of counsel submitted here within. But unlike 99% of cases, here there is clear extrajudicial evidence showing the true reason for the rulings was, in fact, a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants. The evidence of Judge Matta's misconduct via visa, her father discovered only after trial, supports a finding of bias which does arise from an extrajudicial source and not merely an adverse ruling themselves, and disqualification may be separately supported on the basis. Conclusion. For the reasons stated above, Laura respectfully requests Family Court Presiding Judge Honorable Rhonda Fisk review this matter and find the grounds exist to disqualify Judge Matta and promptly reassign the matter to a new judge. In addition, given the clarity of the evidence and severity of misconduct and harm caused to the judiciary as a result, Laura further requests the presiding judge refer the matter to Arizona Commission on Judicial Conduct for further investigation and action as may be appropriate. Okay, well, Owens wanted to turn them over to the authorities. So since she was turned over to the authorities, now they're wanting to turn Judge Matta into the authorities. And this was dated July 8th, 2024. Signed, David Gingras. Once again, I don't think this is within the 20 days. July 8th. And June 10th, when these incidents happened, or at least this father one, that's more than 20 days. Now, with the adverse ruling one, or the Planned Parenthood is closed on Sunday remark, that one is within the 20 days. But I think this father one is outside of the 20 days because he knew about it. And there is clear and convincing evidence that he knew about this because he posted it on his blog. But that's just me. Okay. Now he has, and he submitted it to the people and all that. All right. Affidavit of David S. Gingras in support of petitioner's notice of change of judge for cause. So what do y'all think about all of this stuff before we get into his affidavit? But I personally don't think that there should be a new judge. But at the same time, if she didn't gain that from common sense knowledge or anything that's evidenced in a case, I mean, should she get in trouble for that? Maybe. I mean, she shouldn't be looking things up on the internet if she knows she shouldn't. But what do y'all think? Do you think he has any valid points? Do you just not like him and don't like anything he says, so you can't agree with anything he says? Um, but all right, we will move on. I, David Gingras, hereby swear and affirm under penalty of perjury as follows. My name is David Gingras. I am a United States citizen, a resident of the state of Arizona, am over the age of 18, and if called to testify in court or other proceeding, I could and would give the following testimony, which is based upon my own personal knowledge. I am an attorney licensed to practice law in the state of Arizona since 2004 and in California since 2002. I am an active member in good standing with the State Bar of Arizona and California, and I am admitted to practice and in good standing with the United States Court of Appeals for the 6th, 9th, and 10th Circuit, the United States District Court for the District of Arizona, and the United States District Courts for Northern, Central, and Eastern Districts of California. This affidavit is submitted pursuant to Rule 6.1A of the Arizona Rules of Family Law Procedure, ARS 12409. As explained below, I have cause to believe, and grounds I do believe, that on account of bias, prejudice, or other interests, the judge currently assigned to this matter, Honorable Judge Julie Matta, is unable to act fairly and impartially and is unable to provide Laura or Miss Owens the fair trial, including a fair retrial, which Miss Owens is currently requesting. Of course she is. I don't think she's going to like the outcome if she does get a new one. For these reasons, Laura requests that Family Court presiding Judge Rhonda Fisk find that Judge Matta is disqualified from all further proceedings in this action and that the case be immediately reassigned to a new judge pursuant to Family Law Rule 6.1D4. Case summary. Good God. Why? Case pro se. They had sexual relationships 11 days later, 5 separate occasions, Banner urgent care, positive test. Like, why do we need this again? 2 more positive tests. Denying. Okay. Blood test done. Mom doc. After learning she was no longer pregnant, she filed answered the petition. Okay, so he's bringing up Rule 26. Shortly thereafter, Laura retained counsel, Linball, summary. And then it talks about, okay. So now, summary of media and public attention. Okay, this is where I want to read. That other stuff was just a regurgitation of what he stated before. Despite being an otherwise simple and short-lived paternity matter, this case quickly gained local, national, and even international media attention and massive public scrutiny via social media, because it didn't gain that due to, like, it wasn't like reported on the news. And the Sun was contacted, but that was Laura's doing. Laura liked to bring some immediate attention to this. But really, it was mainly on YouTube. It wasn't just out there on TVs being reported. It took a while before we could get anybody other than it being reported on independent journalists and stuff like that. The media attention is relevant and or first famous result of this recent appearance on a nationally televised reality TV dating program called The Bachelor. This media attention is relevant and important to understand the basis for this notice because it appears the trial judge, Julie Matta, allowed significant media hype and public attention to overwhelm her better judgment, eventually causing her to engage in conduct which violated Laura's right to due process, including her right to have this matter heard by a fair and impartial jurist. Because the issue is key to understanding what happened here and the grounds for disqualification raised by Laura, this subject is discussed in some detail below. For anyone who is not familiar with the show, The Bachelor is a long-running reality TV dating show that first aired on ABC in 2002. The show involves a single male star, The Bachelor, who is presented with a number of female contestants, usually around 25, from which to choose a potential fiance. In addition to The Bachelor involving a single male lead, the show has several spin-off series, including The Bachelorette, involving a single female lead, and other reality shows. Over the course of a season, which lasts for many weeks, The Bachelor goes on. Okay, who cares what The Bachelor is doing? That has nothing to do with this case. There's a rose ceremony. Will you accept this rose? And then the marriage proposal, ideally with the last woman standing. Okay. Like, that has nothing to do with this case. Clayton appeared as the star of Bachelor Season 26, aired ABC from January 3rd to March 15th, 2022. As a result of his appearance on his popular watch show, millions of viewers, Clayton gained some degree of nationwide fame, and his role on the show was heavily promoted and advertised by ABC as is true of all seasons of the show. And then here is a picture of something on his season, some advertisement for Clayton's season. This leads to the second aspect of this case, which caused it to gain far more media and public attention than normal. As previous star of the nationally televised TV show like The Bachelor, Clayton has a large and highly devoted fan base, including many followers on social media. For example, currently has nearly 300,000 followers on Instagram and more than 60,000 followers on TikTok. Okay. Did he get all these from The Bachelor? I would like to know what his numbers were prior to this, and then how many also came, because that was 2022. So if you take his numbers from 2022 and what his numbers were there, and then you take 2023 to 2024 right now, how many of those were from The Bachelor being The Bachelor, and how many of them were for justice and to support Clayton and the injustice and lies that are happening to him? Because not everything came from The Bachelor as you want to claim. This part is just like Depp v. Heard, where everybody wanted to say, oh, Depp was this and Depp was that. Well, there's a bunch of people that don't watch Johnny Depp that often, that didn't watch Pirates of the Caribbean or not into that type of thing, but were supporting Depp not because he was more famous than Heard, but because the evidence showed that she was a liar. But of course, everything has to be, oh, he's a celebrity, so everybody's going to believe him. No. If he would have been what Owens claimed, then he would have lost a bunch of followers. Nobody would want to deal with him. And when you first hear about this, you're like, why would somebody lie about this? Because it's so easy to prove. But, you know, here we are. It didn't turn out that way. It's not, oh, just because he's a famous person somewhat, everybody just sides with him just because. I don't think that's how things work. I would like to think that people have more depth than just that. Because things come out about celebrities all the time. Bad things. And guess what? Not everybody is like, well, I don't care. I like them. No. There's a lot of people that are like, you know what? I don't condone this. I'm not supporting this anymore. I don't want to have anything to do with this. I I mean, look at the P. Diddy stuff. R. Kelly, like things like that, where people weren't just like, well, he's a celebrity, so we're going to believe him. Like, we're going to still support him. No, that is not what happens. But if you want to just see these things one-sided with your blinders on, go ahead. So, and then he gives his Instagram and TikTok and the Wikipedia for that page. These facts, Clayton's fame and huge popularity of The Bachelor, coupled with the extremely odd allegations in this case, i.e. that Laura faked being pregnant with Clayton, have caused this otherwise simple case to gain massive amount of public scrutiny and attention from local, national, and international news media. In addition to being widely covered by traditional news outlets, what news outlets covered this case during all this? Because I don't know of one. I don't think Entertainment Tonight. I don't think TMZ. I don't think ABC, NBC. None of them covered this. So not traditional. No, it wasn't covered by traditional news outlets. Maybe after the fact, it was getting covered. But during all this, it was not covered national. It was not covered on traditional news outlets. Did it get massive attention on social media, including sites like Reddit, Twitter, and YouTube, among others? For instance, anonymous fans of Clayton's have created social media pages focused entirely on this case, including a Twitter account using the hubristic Justice for Clayton, or JFC. The JFC Twitter account has posted obsessively about this case nearly 3,500 times. Okay, there is a lot of pages, Reddit pages, and Twitter pages, and Facebook pages that all are for causes. The case we're covering right now, Justice for Sandra Birchmore. They have a page. They have a Facebook page. They have a Twitter page. They can post about it. That's how you get awareness out. That's how you put all of the facts and stuff and things that have to do with the case in one area, so that if anybody is looking for something, they can go to those places, and that's where they're going to probably find the information, because they're going to have it. Like, this is not uncommon in this day and age. Now, this post, on the other hand, I think we could have gone without the comment. That is just me. If other people don't agree, okay. But wishing a happy and safe 4th of July to everyone but Owens and Gingras. I think if they would have just said wishing a happy 4th of July to everyone but, this would have been okay. I think the fact that they put safe and then excluded them two was a little too much. Because that right there shows something that is not what we should stand for in the people that are supporting Clayton. We should not be wishing harm on anybody. And I do not think that's what that meant. But you cannot even have that look that you think like that, because that type of post, he's able to use that and be like, see, they're crazy and they wish harm on Owens. That's what they get to say with this post right here. I don't think there was any ill intentions in posting about this, but it doesn't make us look good. I don't know who actually posted it that's behind that. But it's now in a court document. In addition to posts on Twitter, anonymous fans of Clayton have created websites devoted solely to this case to promote their beliefs that Clayton is somehow a victim who deserves justice. One such pro-Clayton fan site is justiceforclayton.com. which contains copies of all or substantially all pleadings filed in this case. This site also contains a one-sided narrative which highlights only those facts favorable to Clayton's version of events, while carefully avoiding any discussions of facts unfavorable to Clayton's narrative. Well, the fact that we have the filings on there to back up each of those things, and everything is cited with here's where you can find that fact, that kind of goes to back up all those things. So it's not just a bunch of rumors and he said, she said, all that stuff. This is in pleadings. And guess whose side is covered in pleadings? Owens' narrative is in there and Clayton's. And most everybody covers your filings and Woodnick's filings. And at this point, I would say we have covered more of your filings and Owen's filings, which is her side, than we have Woodnick's, because you have put out way more than Woodnick has. And you haven't even been on the case the entire time. But we have covered more of your filings than anybody else's. So how can you say that we don't cover both sides of the narrative? It doesn't make any sense. In addition to social media posts from his fans, Clayton himself has been extremely personally active in public promoting this case, giving countless media interviews in which he tells his side of the story. Okay, and Owens could do the same thing. Nobody wants to talk to her because I think a lot of people have asked to talk to her and she doesn't want to go talk to anybody. She could be going out there and talking just like Clayton is. She just doesn't. She writes her Medium articles where she is in control of everything and she can edit things if she needs to. Whereas if she goes on a live interview or does something like that, it's just more fuel added to the fire against her because she's likely to say something that's contradictory to something said before. Clayton's attorney, Mr. Woodnick, has also published statements regarding this case, including a press release issued on March 7, 2024, in which Mr. Woodnick accused Laura of fraud, suggesting she has been accused of fabricating pregnancies and doctoring medical evidence as a means to extort relationships several times dating back to 10 years. Show me where that's false. Show me where that is false. Because she admitted to it in her deposition. Hold on, guys. The dog needs to be let out. I'll actually show you the dog first. Hold on. Come here. Come here. Rudy? You want to show people? Here. This is Ivy. Where is she? There we go. Look. There's Ivy. This is our wiener dog. She's the princess. But I'm going to let her out real quick. I'll be right back. Okay, she wanted out of the room. Usually she has to be in here with me. Okay. Oh, thank you. See here. Okay, yeah, so show me where what Woodnick stated was not true. He's allowed to issue a statement. You issue your blog post statements all the time. So, like, what's the difference? Like, you do things as well, and you do things more often than Woodnick does. Oh my God, Woodnick issued one statement on March 7th claiming things after the deposition to let people know what we had found out. But Gingras can make 20,000 blogs. In attempt to respond to some of this one-sided narrative, acting at Laura's request with her written permission, I have occasionally posted comments about this case online, primarily on my personal website and on my Twitter, which you should not do because your PR sucks. The purpose of these comments has been primarily, if not exclusively, to respond to information being circulated about this case by Clayton, his lawyers, and his fans/supporters. Yeah, you need to just say supporters. But you don't necessarily respond to information being circulated. You are asked questions that you don't have a good answer to, so you ignore them and act like they don't exist. Or you block people. You just beat on your chest like you're just this big guy. Oh, look, I'm ruler of everything. I know more than you plebs. And when you don't have anything to refute what Clayton's supporters say, you act as if it doesn't exist. And that's just not going to work. We showed you lies upon lies upon lies, and you move the goalpost every time. I could have somewhat respected you if you would have just been an attorney fighting for Laura, because everybody deserves to have an attorney and fair representation and trial and all that stuff. And you're doing your job. But the fact that you say that you still believe her, knowing that she lied, and she still continued to lie, and to me, blinded you with the fact that nobody knew about Los Angeles, and you don't have any information on Los Angeles, and you still want to say you believe her. You believe she was pregnant. I just can't with you after that. Reasonable minds can differ, but the fact that you are not holding her accountable for certain things, and you think that she's still telling the truth, makes me question you big time. That is not you just doing your job as an attorney. That's believing nonsense. And you have less of a brain than I thought. My personal opinion. YouTubers Dave Neal / Megan Fox, before discussing the specific issues and conduct giving rise to Laura's request to disqualify Judge Matta, it is important to understand some of their participants who will be mentioned further below. Two such participants are individuals named Dave Neal and Megan Fox. I do not personally know either Dave Neal or Megan Fox, but during the course of the proceeding, I have become generally familiar with them. Sir, don't act like you don't watch them and you don't follow them and you have responded to things with them. You know exactly who they are. But during the course of the proceeding, I've generally become familiar with them. According to his YouTube channel, Dave Neal is a stand-up comedian who lives in Tennessee. Dave Neal also creates and publishes videos on YouTube nearly every day. Dave's videos often focus on The Bachelor and people like Clayton who have appeared on the show. Then, oh my God, why is it a surprise that he would cover Bachelor news involving a former Bachelor? That is so outside his niche of his channel. No. That's why he knew about this, is because he's into all of that. The same with Reality Steve. That is their niche. Over the last several months, Dave Neal has obsessively published hundreds of hours of videos regarding the case, again, often on a daily basis, as reflected on his YouTube channel below. Okay, I believe he's a citizen of the United States and has freedom of speech. It's his channel, as you stated. These videos are generally almost universally devoted to viciously attacking Laura and often me, and to proclaiming that Clayton is a victim who deserves justice. Why did they go after you? Because you were going to throw their obituaries in the trash. You called them pawn scum. As soon as you got on this case, you took shots. Shots were fired. And you were so disrespectful. You could have just ignored them. You could have been like, yeah, there are people out there that do support him, but I'm not worried about them. I'm worried about my client and my part of the case. But no, you wished for these people to have obituaries. You wished for these people to be homeless. They were pawn scum, cockroaches. So don't sit here and say that Dave Neal has put all this stuff out without like a reason. You're missing some context in your little description here. He's allowed to have an opinion after the things that you said and did to him. And the email that you sent to him that he did not share until after the hearing on June 10th. He waited. And some of that stuff was so disgusting. So I don't think Dave Neal is necessarily the one that needs to check himself. Did he report on this? Yes. But he's allowed to post and talk about whatever he wants on his channel. That's his right. You don't have to look at it. You don't have to listen or watch. Neither does your client. Worry about your own stuff. Clayton has personally appeared in several of Dave Neal's videos, and it is clear that Dave Neal is not covering this case as a neutral journalist, but rather as a passionate, obsessive advocate for Clayton. He's allowed to have picked a side. He doesn't, I think he started out neutral. But there comes a point when you are going to lean one way or the other. Like, I try to be neutral. I don't, but everybody knows where I stand. But I am going to give props where they go. Whether somebody likes that or not, I am going to try to look at both sides. And just like, yes, I follow the Justice for Clayton or Justice for Laura Owens victims. I follow them on Twitter. I am usually in support of everything they do. But I am also not afraid to say that a tweet that was put out was not okay because of some of the context. I'm not just going to be biased on one side. I'm going to call it like I see it. And that is my right. That is Dave's right. That is Megan's right. If they, whatever they want to do on their channels, they are allowed to do. And because we have facts and evidence that support our cause, doesn't mean that we can't be neutral. All of us, including Dave and Megan, have said if she can show just 1 ounce of proof, once we get these HIPAA forms Will this prove it? No, that didn't prove it. Once we get this, will that prove it? No, we still don't have any proof that she was pregnant. And then we have doctored evidence after doctored evidence after doctored evidence. But all of us have just been waiting for one single piece of something to show that she was, in fact. And you know what? All of us would then come on and say, you know what? All this time, we thought this. But lo and behold, this has been, we've checked it for fabrications and doctoring and all this. And there's a doctor that's a real doctor that actually saw her and all this stuff. Like if this Los Angeles information came back and they were like, yeah, we saw her, here's all her medical records, we would have to come back and say, okay, she wasn't lying. She was, in fact, pregnant. But nothing like that exists. So Dave Neal can choose a side. You've obviously chosen a side as an attorney. Now, you can just have that side because you're representing her, but you've chosen that side as a person removed from this and an attorney, which is your right. It's just not what is based in reality, in my opinion. Okay, let's move on to the next page. I went off on a little rant. Another YouTuber following the case is an individual using the name Megan Fox, who I believe is a resident of New York State. I do not personally know Miss Fox. I believe that name to be a pseudonym. But she has contacted me via email several times during this case, and I understand that she claims to be a journalist who publishes stories on extreme far right-wing news website. Okay, she does. Like, there's proof of that in her articles that are posted that she shares that are on PJ Media. But okay. Like Dave Neal, Megan Fox also creates and publishes videos on her YouTube channel. Like Dave Neal, Megan Fox is a passionate supporter of the JFC cause, and her videos are overwhelmingly devoted to exposing and destroying Laura while promoting the narrative that Clayton is an innocent victim who deserves justice. Well, that's what she believes, and that's her right. She has a right to her own opinion. Dave Neal and Megan Fox are mentioned because they are relevant to the issues raised herein. This is so because they attended the trial in this matter on June 10th, 2024, and after the trial, both appeared on video claiming to have or speaking with others who claim to have direct knowledge regarding certain improper conduct committed by Judge Matta during the trial, including the fact that Judge Matta allegedly engaged in improper ex parte discussions about the case with her father. No, they did not say that. You look stupid. The Judge Fisk could watch every bit of the hundreds of hours done on this case, and they will not find, and they can go on Dave Neal's and watch all the hundreds of hours of footage, and they will not find anyone stating that they talked to the father themselves. They will not find that anybody said that Judge Matta talked to her dad. There is said to be hearsay from somebody else that he was there. Dave Neal nor Megan Fox saw this man. They were just told by a person, and then it was stated that supposedly he was there and he was watching. But it's still, you will not find anywhere where it says Judge Matta told him to come watch this shit show of a case. You're not going to find that on any footage anywhere. But have at it. Who also personally attended the trial and socialized with members of the JFC group. He was socializing with people next to him at a trial. Who cares? There could have been Owens people there. It's not, once again, it's not anybody's fault that Owens doesn't have anybody there sitting in the overflow room. That she has like one person sitting in the courtroom. Yeah, Megan was in the courtroom. Lauren was there. Guess where Dave was? In a van outside the courthouse, not inside the trial. Those points are explained further below. Summary of pretrial judicial bias. Shortly after I became involved with the case in late March 2024, several events occurred which initially caused concern regarding Judge Matta's possible bias and lack of neutrality. Specifically, immediately after Laura retained me to represent her in this matter, I obtained a copy of her file from the previous counselor. Okay. Unfortunately, Laura's prior counsel did not promptly respond to request. This made it impossible for me to respond to a motion to compel filed by Clayton before I was retained. The response to the motion to compel was due mere days after I was retained. Okay. Well, he could have responded to it. Laura could have responded to it in the meantime. That just because you get a new attorney doesn't mean that the judge has to extend things. Can they? Yeah. But when they're tired of dealing with this case, and this case has lasted way longer than it should have, she can just say no. That's her right. Because I could not respond to the motion to compel without a complete copy of Laura's file, and because Mr. Woodnick refused to agree to an extension of time on April 1st, 2024, Woodnick doesn't have to agree. He's not on your side. Why is he going to purposely make things easy for you, especially after the things that your client has done? I don't think he's purposely going to make anything easy on your client after the shenanigans she's done. I filed a lengthy and well-supported motion seeking an extension of time to respond to the motion to compel. The motion explained the request was primarily based on the fact that I did not have a complete copy of Laura's file because previous counsel did not promptly provide the file to me. Despite the fact good cause existed for my request for an extension, and despite the fact Mr. Woodnick did not oppose the motion, just days later on April 3rd, 2024, Judge Matta issued a one-sentence minute entry. File April 5th, 2024, denying my extension request without any explanation. She doesn't have to give you an explanation. We like it when she gives explanations because we are nosy. But she doesn't have to give a reasoning. She didn't have to give all those reasonings in her findings after the hearing. I'm glad she did because I wanted to know her thoughts. But she really could have just said, the ruling is she is going to be sanctioned. She is going to be turned over to Maricopa County Attorney General, and she's going to owe attorney's fees. And she didn't have to put any of her reasonings in there in her judgment that she put out. I am so happy she did. Just like I like it when judges at the end of sentencing, they let the people have it, or they tell the people what they think. I like to know what the judge is thinking because they have to be unbiased throughout. And they have to sit there quietly and call balls and strikes and everything like that. And they have to keep everything inside. And then when sentencing comes, they're allowed to just let it all out. And I like when people do that. I like when the judges do that. Not all of them do it because they don't have to. I just enjoy it because I'm nosy and want to know what they thought of the evidence too. But that's me. Always lose my place. As a lawyer who has practiced exclusively civil litigation for more than 20 years, it is extremely unusual, essentially unheard of in my experience, for a judge to deny an unopposed request for a short extension of time regarding a simple discovery matter, which, when good cause clearly exists for the request, when no prior extension request had been made, and when the other party would not be prejudiced by the request. In fact, having litigated hundreds of matters in state and federal court over the courses of my career, I cannot recall a single prior instant where a similar request was denied. Because there doesn't need to be anything. Like, she needs to hand over the information, plain and simple. We've been waiting for way too long, and the fact that we even have a motion to compel because she has not followed through with things, I don't think you need an extension. Turn over your shit. Tell your client to turn over her shit. And guess what? She still did turn over all of her shit. And I don't know that you haven't done any family law cases, or you haven't done things like this. So I don't know how much you have been in family law. Maybe that's just how it works in family law. Of course, I am also well aware that as a matter of law, adverse judicial rulings alone do not support findings of bias or partiality without showing of extrajudicial source. Okay. For that reason, I determined that although Judge Matta's unexplained and apparently baseless denial of my extension request raised concerns about possible bias, the adverse ruling standing alone could not support a finding of bias. As such, I took no action at that time. Yeah, because there was nothing to do about it. Like, she had the right to do it. You don't have to like it. Plenty of attorneys don't agree with judges' findings all the time. Watch the Karen Reed trial. There's a lot of things that we don't agree with Judge Bev on. Shortly thereafter, I discovered that the motion to compel Clayton's counsel, Mr. Woodnick, made multiple statements to the court which appeared to be knowingly false. I would like to know what the knowingly false statements are. I guess we're going to find out, because apparently everybody's a liar except for Gingras. After I confronted Mr. Woodnick with these concerns, he refused to speak with me by telephone for several weeks. I wonder why. Given the fact I was newly retained and not familiar with the complicated history of this case, Mr. Woodnick's refusal to speak with me made it much more difficult to prepare for this trial. Maybe the things that you did when you came on to this case Easter weekend weren't that great. And I don't blame anybody for not doing it. Had you come in cordial and nice and wanted to be just civil in this case, things probably would have gone a lot smoother for you. But you came in acting like a jerk to everybody and anybody. And that's just, you're going to collect more bees with honey than being a jerk. For that reason, on April 8th, 2024, I filed a motion entitled Motion to Compel Lunch for Alternative Relief. In that motion, I informed the court that Mr. Woodnick was refusing to speak with me by phone, despite multiple rules of procedure and professional conduct, which required counsel to meet and confer by phone. Well, he wants everything to be on the record and with emails. And he doesn't trust you or your client because of the way you came in. I guarantee you, if Corey Keith would have asked to go to lunch to talk about the case, I bet Woodnick would have gone to lunch with Corey Keith. And he probably would have gone to lunch with Alexis Linvall. So why wouldn't he go to lunch with you? Because you're a jerk. As a result, I asked the court to order Mr. Woodnick to speak with me in addition to other alternative relief. You want everything on a phone call. You want everything off the record. People don't want to do that. To support that request, my motion cited an earlier ruling from Honorable Pendon Grimes, deceased in Physician's Choice of Arizona Miller case, in which Judge Penny Gaines granted a virtual identity request, noting the court has rarely seen a motion with more merit. The motion to compel lunch will be granted. Well, that was that case, not this one. I bet there wasn't a rude jerk of a lawyer on the other end of the other one and scheming and stuff like that the judge had proof of. Unfortunately, as she did with my request for an extension of time to the motion to compel on April 30th, 2024, filed on May 1st, 2024, Judge Matta issued a single sentence minutes entry denying the motion to compel lunch. The order denied my request without an analysis or an explanation. Once again, she's allowed to do that. Later the same day, on April 30th, 2024, I learned for the first time that Clayton's counsel intended to use previously undisclosed evidence and witness at trial. Due to the untimely and extremely late disclosure within the hour of this discovery, I filed an emergency motion bringing the issue to the court's attention, and I requested an immediate scheduling conference to discuss the issues further. Despite the fact that Rule 76.1 provides the court must order a scheduling conference when requested, on May 22nd, 2024, Judge Matta issued a minute entry order denying my request for a scheduling conference, again without any explanation or analysis. Despite that, the court must order a scheduling conference when requested. Let's see about that. Sorry, we are going to hopefully be done soon. Arizona Rule 76.1. A party made. Okay. The court must hold a scheduling conference to formulate a plan for trial, including procedures for admitted evidence, presenting witnesses, and filing a pretrial statement. Well, they already had those. Unless the court orders otherwise, the parties must file the documents in these. Okay, but she already had a scheduling conference. Just because you weren't on the case then doesn't mean she didn't have one. She did. She doesn't have to have one every time somebody requests one. Because you could request one every week and then she would have to do them every week. And that's just not what she has to do. Taken again, Judge Matta's single sentence, zero explanation denial of these three motions. Request for extension time, request for order of lunch and just Woodnick to speak with me, and a scheduling conference caused me to have serious concerns regarding Judge Matta's possible bias and lack of neutrality. But it's not the first time you've had, like, any attorney has had a bunch of things get denied in their case. Like, that's just not how everything has happened. However, I continue to believe that despite the existence of what appeared to be apparent bias and hostility, well, you're hostile. Judge Matta adverse rulings alone would not support a finding of bias sufficient to seek her disqualification because of the rule party challenging a trial judge's impartiality must overcome a presumption that the trial judges are free of bias of prejudice. And the Corley standard that advisory rulings alone do not support findings of bias and partiality without showing of an extrajudicial source or bias. Okay, so then why are you stating this stuff? Because she's allowed to make a ruling on them. Just because it wasn't in your favor a lot of times because you came in at the end of the case doesn't mean anything. Deep-seated favoritism. Summary of judicial misconduct and bias at trial. This matter proceeded at bench trial before Judge Matta on June 10th, 2024. Prior to the trial, I learned that Dave Neal and Megan Fox, among other JFC supporters, were planning to attend the trial in support of Clayton, and they're allowed to. It is my personal belief that courts are publicly funded for it. Trials and legal proceedings belong to the public and should always remain open to the public. Okay, then why are you saying stuff? I further believe that as a matter of law that members of the public have the near absolute right to observe and report on events which take place in court, so I viewed the public interest in attending and observing the trial as a good thing. Okay, great. And anybody that supported Owens could have come and sat and watched the trial too. However, when I arrived at the court that morning of trial, I was surprised to see dozens, if not hundreds of people waiting to watch the trial. Before trial began, Judge Matta spoke to counsel in her chambers and informed us that she had created an overflow room for at least 50 observers to watch the trial, and the seated in the courtroom itself was packed with spectators. Judge Matta informed counsel that she had taken certain security precautions due to the large crowd of spectators. Okay, seems all right there. I found Judge Matta's comments about the crowd surprising because prior to the morning of the trial, there was nothing filed in this matter aside from a small number of media requests for filming that would suggest such a large crowd was likely to attend. Okay, well, just because you didn't think so, then that doesn't mean anything. Based on this, it appeared Judge Matta gained some personal knowledge regarding the likely crowd size that was not obtained from nor shared with the parties or counsel. It was all over the internet. You knew about it. She could have seen it all. People could have been like, hey, there's a lot of people. Like, maybe the clerks were like, hey, we've had lots of people inquiring about how many seats are going to be available to watch this trial and if it's even worth all this stuff. She's allowed to determine this stuff. And it's not the first time a judge has done this. Shortly before trial began, I became aware that Mr. Woodnick intended to call a witness named Michael Maraschini. Shortly before the trial began, you became aware of this? I believe you were told about this prior to the end of discovery, which was what, on May 10th? 30 days prior? You had known about it for a whole month. So it's not a surprise that you found out about. Mr. Maraschini is an ex-boyfriend of Laura's. The prior dated approximately 2 years while living in San Francisco in 2016 through 2017. During the relationship, Laura claimed that Mr. Maraschini violently assaulted her, causing her traumatic brain injury that eventually resulted in Laura developing epilepsy. Except for that's a lie because it's stated in an Uber filing that it's otherwise. Based on the abuse, Laura sought and obtained a domestic violence restraining order from the San Francisco County Superior Court, a copy of which is attached here too as Exhibit A. Yes, Exhibit A is Maraschini's restraining order, which we have gone over in the Maraschini series on this channel. The order, later renewed, remained valid and is in effect of today. On June 9th, 2024, Clayton posted a video on his Instagram page standing next to Mr. Maraschini. He appears on the right as shown here. In this video and elsewhere, Clayton suggests that Mr. Maraschini intended to appear at the trial in this matter, despite the DRVO issued against him. He was given a subpoena. On the morning of June 10th, Laura informed me that she saw Mr. Maraschini in the courthouse with Clayton and Mr. Woodnick. Based on this, Laura told me she was too terrified to participate in the trial, and she told me she intended to leave unless the DVRO was enforced. Okay, bye. Having no other available options, I immediately contacted court security and asked them to enforce the California's court order by removing Mr. Maraschini from the facility. The security Superior Court security officers informed me they did not believe they had authority to enforce the order, and that they suggested the only option was to call 911 and ask Phoenix PD to enforce the order. Based on that suggestion, I called 911, explained the situation, and asked the officers to enforce the order. After a few minutes, Phoenix police responded. They reviewed the California court orders. I explained to them that pursuant to federal law, the Violence Against Women's Act, the VAWA, 18 USC 2263, they are required to enforce the California court order as written. I provided the officers with a copy of the specific provisions of the VAWA, which made interstate enforcement of the order mandatory, and I directed their attention to specific language of the order shown here that required the order to be enforced in all 50 states. You just had this handy, but you didn't know until the day of court that he was going to be there. But you just had this handy, and you made threats to have him arrested prior to. Okay, not buying it. Restraining protective order meets all full faith credit requirements of the Violence Against Women's Act. Upon notice of the restrained person, the court has jurisdiction over the parties in this subject matter. The restrained person has been or will be afforded motion and timely opportunity to be heard as provided by laws of the jurisdiction. This order is valid and entitled to enforcement in each jurisdiction throughout the 50 states of the United States, the District of Columbia, and all tribunal lands, and all U.S. territories, commonwealths, and possesses and shall be enforced if it were an order of that jurisdiction. I also explained by traveling from California to Arizona for the purpose of violating the order, Mr. Maraschini committed a federal crime pursuant to 18 USC 2262, and that Laura desired his arrest and prosecution. He had a subpoena telling him he had to be there. So, I mean, he was going to be screwed over in one way or another, because he would have been breaking some court's order in one state or another, but a judge told him he had to be there, so he was there. He didn't just fly over there of his own free will and as a spectator. He was there to speak. Despite the Phoenix police indicated they believed that they had no choice but to defer to Judge Matta on this issue. As a result, immediately prior to the start of trial, I asked Judge Matta on the record to enforce the California court order by removing Mr. Maraschini from the courtroom. As she had done with substantially every other request, Judge Matta denied my request without any explanation. As a result, Laura was forced to sit in a court just feet away from Mr. Maraschini, which caused her to nearly become overwhelmed by fear, panic, and anxiety. No, it didn't. We watched. She didn't have any of that. At the conclusion of trial, I informed Judge Matta on the record that I was leaving the country later that evening for a family vacation in Europe to celebrate my mother's 80th birthday. I don't know if you said it was for the 80th birthday. You might have, but I just knew you were leaving the country. I left Arizona the evening of June 10th and remained in Europe until I returned home on June 28th. The majority of this time was spent on a cruise ship in the Mediterranean with my family, and during that time, my internet access was extremely limited. Okay. The ship's Wi-Fi connection was so slow that I was unable to view videos posted on any medium, including Twitter and YouTube, during the cruise. Okay. While I was on vacation, Laura contacted me and told me about some extremely disturbing information being shared on social media by Dave Neal and Megan Fox. You knew about this. Mr. Neal and Miss Fox appeared in several live streams and other videos in which they claimed Judge Matta's father was present in the overflow room during the trial. They claim Mr. Howe spoke with several of Clayton's supporters during and after the trial, proclaimed, "I'm here for the shit show." Another individual claimed that Judge Matta's father sat with them and expressed that he was here for the circus. Yeah, you don't have direct quotes from anybody. You have hearsay. Laura assembled excerpts from some of these videos, which are available for viewing here. A CD containing these videos is also lodged here within. As unusual as this may be, the mere fact that Judge Matta's father attended the trial, if true, is not a primary concern. The concern is that according to the comments from Dave Neal, Megan Fox, and others appearing on videos with them, Howe stated Judge Matta discussed fact. No, they did not say that. And if they did, I haven't seen it. One specific statement was made by a person, Have a Derby, who speaks between 0 and 40 seconds in the above video compilation. In her remarks, Ms. Derby claims that she spoke with the Judge Matta's father at or immediately after the trial. Ms. Derby stated that Mr. Howe was carrying papers with him, which, based on her comments, may have been Laura's request for findings of facts and conclusions of law. Okay. Ms. Derby further claims Mr. Howe told her Judge Matta showed her father Laura's request for findings of fact and conclusions of law, and she, Judge Matta, told him, Julie told me just, Dad, you have got to read this, and printed out a copy for him. It is public knowledge. It's a public filing. In the course of making these remarks, Ms. Derby also made statements which appeared to imply that Judge Matta told her father that she intended to rule in favor of Clayton before the case was tried. Who is Ms. Derby? Does anybody know who Ms. Have a Derby is? Like, I may have to go look at this. Because if this isn't good, if this was actually said and if this is true, it's not. Miss Derby claimed that Mr. Howe whipped out papers that Julie printed for him. Then she mentioned Laura's request for finding of fact and conclusions of law, finally asking, did anyone see those were denied prior to trial? Okay, how do we also know that Hava Derby is not an alias created by Owens, just stating things? Like, I don't know who this person is. Do any of y'all? What is also extremely disturbing is that the video compilation, upon hearing remarks regarding Judge Matta and her father, Dave Neal laughingly commented, to paraphrase, hold on, we don't need a mistrial. Yeah, because he was probably uncomfortable with hearing that. The specific comment from Mr. Neal appears between 40 and 1 in the above video compilation. I understood these remarks from Dave Neal as a signal to the person speaking that they should not disclose further information regarding comments they claim to have received from Judge Matta's father because her believed they would expose judicial misconduct and bias. No, that's not what was said. He doesn't want that stuff, and he doesn't need a mistrial. This is why he wanted people to be respectful, don't say anything, just nothing Owens. And he didn't want stuff that could end up that way. And if this stuff was actually happening, yeah, it could cause those things. And he doesn't want that in the pursuit of justice and have to do this all over again. I don't think it was because he wanted to hide things. Assuming Judge Matta did in fact share information about this case with her father, the conduct would appear to be a pro se violation of Rule 2.9a of the Arizona Code of Judicial Conduct. Despite these allegations, my personal view based on past several months is that Clayton's followers are generally not honest or reliable. Okay, well, that's your opinion. and I consider the possibility of the claims made regarding Judge Matta's father may be fabricated, either in whole or in part. No, you don't. And even if you think that, you're hoping they are true because you want her disqualified. Or your client helped fabricate some of this stuff, because I don't remember seeing some of this other stuff. I remember hearing that he was in the overflow room. And that's pretty, and he was here to watch it. That's about what I remember. Given how serious the issues were, I do not believe I could ethically make a formal accusation of judicial impropriety without taking some reasonable steps to verify the truth of what happened. See Rules Arizona Professional Conduct, ER 8.2. A. Providing a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge. In an effort to ascertain the truth while on vacation on the morning of June 17th, 2024, before I received the post-trial decision, I sent an email to Judge Matta's division in which I raised concern regarding Judge Matta's father and the alleged statements made by Dave Neal and Megan Fox at the time. I had not yet seen Miss Derby's remarks. A true and correct copy of this email is attached here to as Exhibit B. In this email, while noting highly unusual circumstances, I asked Judge Matta to promptly provide a response to the allegations regarding your father. I further explained that if these allegations were true, I believe they may support a change of judge for cause. Okay, good for you. Doesn't mean she agrees and gives merit to anything that you have to say. In this email, while noting the highly unusual circumstances, I asked Judge Matta to promptly provide a response to the allegations regarding her father. I further explained that if these allegations were true, I believed. Okay. A few hours later, I received an email response from Judge Matta's division stating, to the extent that either party wishes to bring a matter to the court's attention, the court respectfully asks that you file an appropriate motion. A true and correct copy of this email is attached hereto as Exhibit C. Other than this brief response, Judge Matta did not admit or deny the allegation concerning her father. Okay. So he sent a thing on the morning of June 17th. About 14 hours later, on the morning of June 18th, I received the court's post-trial ruling on the merits, a copy which is attached here to as Exhibit B. After reviewing June 18th, 2024 decision, which it is dated the 17th, which found in favor of Clayton as to virtually all issues, Laura and I immediately noticed something truly shocking. The ruling contains findings that were not based on any evidence at trial. Instead, those findings were clearly copied from posts on social media. Specifically, to cite just one obvious example, on page 10 of the decision, Judge Matta made certain findings that were purposefully based on trial testimony of Clayton's medical expert witness, Dr. Samantha Deans. Dr. Deans is an OBGYN who previously worked for Planned Parenthood on the East Coast. As shown below, Judge Matta made a specific factual finding that according to the trial testimony of Dr. Deans, Planned Parenthood is not open on Sundays. And then he shows where it states that in the ruling, whether belaboring the details of this entire history of the case, the question of whether Planned Parenthood was or was not open on Sundays was relevant and extremely important. This is because at trial, Laura testified she sought care from Planned Parenthood location in Southern California on July 2nd, 2023. As it happens, July 2nd is on a Sunday. Therefore, if Planned Parenthood was not open on Sunday in July 2023, absent some other explanation, that would appear to disprove Laura's claim that she sought care there on the day. But yet you still believe her. You still believe her, Gingras. You still think she's telling the truth. Whether the judge looked this up on the internet or not, the fact that you still believe her, knowing that this is a lie, once again, is crazy. But here's the problem. Dr. Deans never testified about the issue at trial or any other time. To prove that point, attached here to as Exhibit E is a true and complete copy of the court report's official transcript, as the index reflects. The entirety of Dean's testimony covers a total of 6 pages. Okay, that's the testimony. What about her expert opinion that she issued in this case? Could that have said something about that? I don't know if it does. As the transcript clearly shows, at no time during the brief testimony did Dr. Deans or anyone else ever address the question of whether Planned Parenthood was or was not open on Sundays. That question was never asked, nor was it answered. If Dr. Deans did testify that Planned Parenthood is not open on Sundays, where did Judge Matta finding the issue come from? The answer is once again absolutely shocking. Judge Matta copied the finding from posts on social media. As noted above, during the course of the involvement in this matter, I have published a small number of comments, approximately 15 posts regarding this case on my personal website, Gingras Law. This is a tiny, insignificant fraction of the commentary published by, okay, great. We're followers, we're supporters, we're allowed to do that. JFC Twitter account has this. The number of posts of social media is in the tens of hundreds of thousands, if not millions. As limited as my online involvement in this case has been, I believe Judge Matta conducted her own independent research into the facts of this case, and this involving her review comments posted on the website, on my website or other social media pages. That belief is based on the following facts. First, throughout the case and repeatedly at trial, Clayton's counsel, Greg Woodnick, complained to Judge Matta about the fact that I was making public statements about this case via my website, Twitter, and Mr. Woodnick specifically provided copies of articles I wrote and posted on Gingras Law about this case. I found Mr. Woodnick's complaint in this regard confusing because the information and comments I posted about this case were not improper in any way. And because Clayton and his supporters, included Mr. Woodnick, had also posted publicly comments online about this case, suggested that Mr. Woodnick fully understood I had a right to inform the public of Laura's side. You do, but you don't have to say it in certain ways, and the way you conducted yourself is not great. And it shows inconsistencies in Laura's timeline. We are not a part of this case. We can make comments. Instead, I believe he was suggesting or hinting to Judge Matta that he should go online and perform an ex parte review of my site. And I believe that is exactly what she did. My belief is based on the fact that I immediately after Laura finished testifying at trial, literally the same day, anonymous supporters of Clayton began posting comments on my website and also on social media asserting Laura committed perjury, and she claimed to have sought care from Planned Parenthood on July 2nd, 2023, because the day was Sunday and Planned Parenthood isn't even open on Sundays. I don't care if it was open on Sundays. She said she went to Los Angeles, and there's no proof that she did. And she kept that. I don't care whether they were open on Sunday. I don't believe it. Even if they were open just for her, I don't believe it. The specific comment was posted by anonymous users on my website on June 10th, 2024, a week before Judge Matta issued her post-trial decision. All right, last page. The evidence supports 2 conclusions. First, Judge Matta finding that Planned Parenthood is not open on Sundays did not come from trial testimony of Dr. Deans, nor did it come from any other witness. Indeed, the word Sunday does not appear in the transcript anywhere. That much is beyond dispute. Okay. But is it in a medical opinion? I don't know if it is. I'm going to have to go back and look. Second, the evidence shows Judge Matta violated Rule 2.9c of the Arizona Code of Judicial Conduct by performing a secret, undisclosed investigation into the facts of the matter, which clearly would have resulted in her seeing comments from Clayton's supporters regarding their beliefs as to Planned Parenthood's hours of operation. The fact that the judge based her post-trial rulings on anything other than admitted trial evidence demonstrates beyond preponderance of the evidence that grounds exist to disqualify Judge Matta from this matter on the basis of bias and the prejudice. The same is true of Judge Matta's decision to have an ex parte discussions about the case with her father. You still don't have proof of that. The legal arguments support those conclusions are set forth in a memorandum of law filed concurrently here within pursuit to family law, Rule 6.1d2, For the reasons stated above, I have grounds to believe, and I do believe, that on account of bias and prejudice or other interests the judge currently assigned to this matter, Honorable Judge Julie Matta is unable to act fairly and impartial, and she is unable to provide petitioner Laura Owens with a fair trial, including a fair retrial, which Ms. Owens is concurrently requesting. Pursuant to 28 U.S.C. 1746, I declare under penalty of perjury under the laws of the United States of America and state of Arizona that the foregoing is true and correct, executed on July 8th, 2024. Signed, Gingras. And then the exhibits are Maraschini's restraining order, a ruling, filing judgment, and transcript of the hearing on June 10th, 2024. Those are the three things that are in there. They may be marked as D or E or something like that, but so we may not have all the actual exhibits, but those are the exhibits that are attached to his thing that I know of so far. I am going to try to find out who this Miss Derby is. I am also going to try to find if there is something that states that it is closed on Sunday or the weekend or something like that. But I am interested to hearing what's going to happen with this. And if Woodnick is going to say anything, if Judge Matta is going to say anything, and if there's going to be a retrial. And if there is a retrial, then, I mean, we're going to probably have the same outcome, in my opinion. But thank you for staying with me. If you did, I know this was a long live. I did not want to attach all the exhibits. I will put the link to this in the description box if you want to go look at all those exhibits and transcripts. I'm not putting them in there. This whole thing was a total of 211 pages. I just wanted to go over his words. But some of this may have merit. I mean, but at the same time, her father, he has no proof. He has no proof of that. And I'm going to go look at that exhibit. I'm going to go click on that thing to see what I see. But I hope y'all have a good rest of your evening. And I did put out part 1 of the internal investigation for Sandra Birchmore. That is up. I will be dropping part 2 probably Wednesday, either tomorrow or Thursday. And so, yeah, so be looking out for that stuff. Please give a like and subscribe so that when we get more information, we will get it out there. And remember, I try to cover this in an unbiased way, calling balls and strikes the way I see it. I don't have to like you to say that some of your arguments may have merit. If Judge Matta, in fact, is not allowed to Google hours of something, and she did, she shouldn't have. And if that's clearly stated, then sadly, Gingras has a point. And this is why people need to do things by the book, because we do not want to give people that are in the wrong outs on technicalities. We need everything to be by the book. So I will see y'all later.